Tonight, the highest court in the land refused to intervene, refusing to hear one of the most explosive appeals of recent times. Ghislaine Maxwell's last legal hope is gone. But the ripple effects? They might threaten to upend the political order. In this video, we peel back the hidden arguments, reveal the stakes, and explore what happens next. From Epstein's infamous non-prosecution deal to claims of elite immunity and political cover-ups. This isn't just a courtroom story. It's a power war. Make sure you watch until the end, because the next twist might come from an unexpected direction. To understand the gravity of today's moment, we need to rewind. Ghislaine Maxwell is a British socialite who became infamously tied to financier Jeffrey Epstein. Over years, she was accused, and later convicted, of playing a central role in recruiting, grooming, and facilitating sexual abuse of minors on Epstein's behalf. Maxwell's trial was a rare moment of accountability in a saga rife with secrecy and elite protection. In December 2021, a federal jury in New York convicted Maxwell on 5 out of 6 counts, including sex trafficking of minors and conspiracy charges. She was sentenced in 2022 to 20 years in prison. But Maxwell never accepted the verdict as the final chapter. Her legal team crafted an ambitious path to overturn it, focusing on a controversial deal Epstein struck in 2007, one that could, they argued, shield her as a co-conspirator. Fast forward to October 6, 2025, the U.S. Supreme Court announced it would not hear her appeal, letting the conviction stand. That refusal isn't just a legal endpoint, it's a flashpoint, rife with implications about power, immunity, and the limits of accountability. Here's the legal mechanics. The Supreme Court denied certiorari, meaning they refused to hear Maxwell's case. They offered no opinion, no dissenting statements, silence. When SCOTUS declines cert, it doesn't mean they endorse the lower court's reasoning, it just means they won't review it. But in practice, the lower rulings remain in force. In Maxwell's case, that means the conviction and sentencing by the trial court and the affirmations by the appeals court stand. Her legal team expressed disappointment and vowed to continue pushing legal avenues. But notice, they won't get fresh scrutiny from the Supreme Court. The High Court's non-action is often viewed as a way to avoid politically incendiary cases. And when that silence comes in a high-profile, emotionally charged trial, it carries its own meaning. This is the legal hinge on which Maxwell's entire appeal hinged. The 2007 Non-Prosecution Agreement, NPA, Epstein struck with prosecutors in South Florida. Under that deal, Epstein agreed to plead guilty to state charges for soliciting prostitution, including minors, and in exchange, federal prosecutors dropped their pursuit of certain charges, and crucially, included a clause promising that the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein. Maxwell's argument, that this promise should bind not only Florida's federal office, but all U.S. attorneys' offices, meaning she should have been shielded from charges in New York. Her lawyers claim there's no geographic limitation in the clause. Opponents, including the Justice Department and the Manhattan U.S. Attorney's Office, argue that the deal only bound the Southern District of Florida. The clause was negotiated in that context, with specific jurisdictional boundaries. They maintain the agreement lacked authority to bind other districts. Lower courts sided with that narrower interpretation. The Second Circuit Court of Appeals reinforced that the NPA didn't protect Maxwell in New York. That fundamental disagreement, how far a plea agreement in one jurisdiction binds others, is a legal fault line across U.S. jurisprudence. Maxwell's petition to the Supreme Court invoked that split, arguing for consistency and enforcement of government promises. But with SCOTUS declining to hear the case, that question remains unresolved at the highest level. Lower courts' interpretations stand, for now. At first glance, Maxwell's appeal is about legal technicalities. But the political and social stakes are far deeper. 1. Connection to Donald Trump. Epstein and Maxwell moved in elite circles overlapping with Donald Trump in the 1990s and early 2000s. Trump once described Epstein as a terrific guy. During Maxwell's appeal process, she gave an interview to Deputy Attorney General Todd Blanche, asserting she never saw Trump behave improperly. A controversial letter surfaced in Epstein's files, attributed to Trump, containing cryptic lines about a wonderful secret, fueling suspicions about deeper connections. Thus, any further disclosures tied to Maxwell or Epstein may implicate influential figures, making the decision to deny review politically expedient. 2. Disclosure, sealed files, and DOJ transparency. Critics have long blasted the Justice Department for withholding key Epstein case documents. Survivors, Congress, and the public demanded full transparency, especially about Epstein's client lists and associates. Earlier in 2025, the DOJ and FBI publicly asserted they had labored to provide the public with maximum information, but insisted that further release would not be appropriate. Many saw that as obfuscation. The refusal by the Supreme Court gives DOJ breathing room, no obligation to reopen sealed materials or face fresh exposure. 3. Unequal justice and elites' immunity. Maxwell is now the only person convicted in connection with Epstein's decades-long trafficking operation. That disparity stirs disquiet. Why were only some prosecuted, when Epstein's network reportedly implicated dozens of associates, clients, or facilitators? Maxwell's case becomes a symbolic stand-in. Critics say she may be taking the fall for others. By declining to engage, SCOTUS may be aiming to avoid a political showdown. If the case were reopened, it could force revelations damaging to powerful figures. Silence is safe. Even Trump's administration has attempted to dampen controversy. He has publicly stated he retains the power to pardon or commute Maxwell's sentence, though no formal request has been made. Some viewed Maxwell's transfer from a Florida prison to a minimum security camp in Texas, after her interview with Blanche, as a politically motivated move. Thus, the Maxwell appeal is not merely a legal fight, it's a power struggle over narrative, immunity, and elite accountability. Though the Supreme Court denied review, Maxwell's legal team still has a few paths, albeit narrow and high-risk ones. A. Collateral motions/constitutional challenges. Her lawyers can press claims in lower courts, new constitutional arguments, newly discovered evidence, or applications for habeas corpus. But success is unlikely without a major breakthrough. B. Clemency/presidential pardon. Because the criminal appeals route is essentially exhausted, executive mercy becomes one of the few lifelines. Maxwell's attorneys have previously alluded to clemency, and Trump has floated the possibility publicly. Yet pardoning someone convicted for sexual abuse of minors carries enormous political risk for any president who grants it. Maxwell has expressed willingness to testify before Congress, but only if granted immunity. Her legal team demanded advanced access to the questions and delayed deposition until after appeals. But Congress rejected granting immunity up front. If she testified and revealed names that tie into Epstein's network, or expose involvement of powerful figures, that could reshape public discourse and spur fresh investigations. Even if criminal remedies dry up, civil lawsuits by victims, or investigations in other jurisdictions, e.g. UK, EU, could surface new evidence or pressure disclosure. But none of these paths guarantee reversal of conviction, and most remain heavily contingent on political will or external events. As we reflect, a few deep questions persist. Why did SCOTUS stay silent? In such a high-profile case, silence invites speculation. Did political pressure deter them? Did institutional interests override legal merit? Was the 2007 agreement intended broadly or narrowly? The meaning of co-conspirator language is disputed. Did prosecutors always intend for it to be limited to Florida or adjacent jurisdiction? Or did they promise sweeping protection? The ambiguity fueled Maxwell's appeal. Are powerful individuals still hiding? Many believe Maxwell is the fall person while others in Epstein's orbit remain untouched. If so, what does that say about accountability at the top? Is the justice system broken? The United States relies heavily on plea bargains and NPAs. If one district's deal can be cherry-picked by prosecutors elsewhere, promises become hollow. Maxwell's appeal highlighted that systemic tension. Will future revelations force a re-examination? A mysterious client list rumor, sealed documents, political memoirs. Any one revelation could reignite public pressure that forces courts or governments to revisit unresolved aspects. The Supreme Court's refusal to hear Maxwell's appeal does not affirm innocence or guilt, it simply lets lower court judgments stand. At the heart of the legal debate is the 2007 non-prosecution agreement Epstein made, especially its co-conspirator clause, and how far that promise should bind across districts. The case isn't just legal, it's political, implicating elite networks, executive discretion, and the narratives of accountability in America. Maxwell still has legal and political options, though each is fraught with risk and uncertainty. Ultimately, this moment underscores a broader truth. In a system where wealth, influence, and secrecy overlap, justice is often partial, and the battle for transparency and accountability continues.